Hello and good afternoon. My name is Annette and today I will be your host. Welcome to today's webinar. Today is going to be a bumper webinar. We have quite a few people registered for this presentation, so please bear with us while people do continue to log on. Before we start the presentation, just some housekeeping rules. If you do have a question during the webinar, please pop your question in the Q&A feature and our presenters will do their best to answer some of the questions that you have at the end of the presentation. Okay, so I'm just going to give it a minute or so and we'll wait for some more people to log on. Okay, with the numbers climbing. Okay. I think we're getting close to capacity, so I think we should probably make a start. Okay, very warm welcome to you all, and we appreciate your time today. We'll do our best today to shed some light on some of the nuances around workplace law changes that are on the horizon. The Australian government recently introduced two major legislative changes to the Fair Work Act and the Anti-Discrimination and Human Rights Legislation Amendment, Respect at Work Act 2022. And these powerful law updates will impact employers and employees alike. So it's crucial that businesses understand the full effects and how to start preparing for these changes. And that's exactly what we're going to help you with today. So today we're joined by Wes O'Donnell and Bianca Cito. Wes, hi, and Bianca, hi. Welcome.
Hi, everyone.
Thank you for joining us. I'll just give you a little bit of information about both Wes and Bianca. Wes is our National Workplace Relations Manager, and Wes is an experienced workplace relations consultant, combining a strong legal background with extensive consultancy experience in the field of workplace relations and employment law. Wes has over 10 years experience assuming senior workplace relations roles in both Australia and London, so very impressive. And Bianca, she's our partner and solicitor at FCB Workplace Law. Bianca is an accredited specialist in workplace relations law and is based in Brisbane. She has been providing clients with industrial relations and employment law advice for over 18 years and has special expertise in advising clients operating in the retail sector. So, Wes, that's all the formalities from me. I'm going to hand over to you.
Great, thanks Annette, and good afternoon everyone, and thank you for joining us for today's session. For those that don't know FCB Group and HR Assured, I thought I'd take a couple of moments just to discuss who we are and how we can potentially support you and your business. HR Assured is part of the FCB Group, which has been trading and in operation for around 30 years. Within our group structure, we have a number of different business units, making us the largest bespoke industrial relations and employment relations firm in all of Australia. Some of those businesses within the FCB Group include FCB Workplace Law, and we're lucky enough to have Bianca, who's the head of Workplace Law, join us today. We also have a visa migration division, FCB Smart Visa, an Enable HR platform, which is Australia's leading HRIS platform, and two quality certification businesses. HR Assured is our subscription-based service, which brings the best elements of those unique business lines together to provide our clients with a holistic support structure in all of their HR and industrial relations needs. We'll provide you with some information at the end of today's session around how you can contact us at HR Assured to discuss how we can be of further support to you and your business. In brief though, HR Assured, as I mentioned, provides holistic services in all aspects of your people management responsibility. We help you avoid the admin and create the culture by providing you with any support needed to identify your compliance needs, but also to enable you to leverage our expertise and systems to drive improvements within your people management function. We'd love to have a conversation with you after today's session around how we can support you and your business further. So as Annette mentioned, there has been the introduction of two significant pieces of legislation recently, which is probably the most significant change to our industrial relations laws for quite some time. We're going to go through those various pieces of law or draft legislation in greater detail with a practical focus based upon things which we believe that you need to be conscious of and anticipate in the introduction of these laws. We'll discuss with you some of the more practical steps that you can take in order to prepare your business for the introduction of these changes and how we can support you through that process. The most significant change in terms of volume is the Fair Work Legislation Amendment Act called the Secure Jobs and Better Pay Bill. This was introduced earlier in October and is anticipated to come into effect prior to Christmas. There's a lot of detail within that particular bill, but we'll take you through some of the more significant aspects of that, which we believe will impact directly on most businesses, and also some of the practical steps which we think you need to undertake in preparation for the introduction of that bill. Bianca will also take us through some significant changes which are anticipated in relation to the sex discrimination legislation. And as discussed, we'll give you some practical tips and guides on how to prepare. As Annette mentioned, we'll certainly leave enough time at the end of today's presentation to address any questions that you may have. So please feel free to raise your questions as we go through in the Q&A or chat function. To the extent that Bianca and I can, we'll try to address some of the questions as we go through the presentation. However, we will certainly try to leave enough time at the end to answer as many of those questions as you can. But don't fear, if we can't get through all of your questions, there will certainly be some details which we'll share with you at the end of the presentation, where you can touch base with one of our experts within HR Assured, who'll be able to answer some of your questions on a more personal and bespoke basis. So let's get into it. The Secure Jobs and Better Pay Bill. As discussed, this is a bill which has been introduced by the Labor government and has principally arisen from the Jobs and Skills Summit, which was undertaken in early September. As you're probably all aware, the Labor government or the Labor Party then rather, went into the election without any significant industrial relations platform, but rather indicated that it would convene a jobs summit after forming government with interested groups, including unions and employer associations, to identify key policy agenda items which it would be delivering within its first term. A number of key policy and agenda items were discussed, and it's been communicated by the government arising from that summit in early September. But the government has indicated that its primary objective that it's pursuing is full employment and productivity growth, being its primary economic driver. Unsurprisingly, from a Labor government, some of the drivers or factors which it intends to pursue in achieving those broad overarching objectives is gender equality and access, believing quite rightly that existing gender equality within the economy is preventing us from achieving our best economic outcome. It also intends to achieve those objectives through improved job security, as well as fairly distributing the benefits of productivity improvements achieved through the labour market and economy as a whole. So broadly speaking, they're the three agenda objectives which the government is trying to achieve in some of the legislation that we're talking about today. Now, the government has introduced a significant bill, as I've outlined already, and it's currently before the Senate for its consideration. The Senate has put that bill into a committee process to review and assess the various components of the bill, and was due to report yesterday, however, has sought an extension of time until the 22nd of November to report back into the Senate. It's likely that the sitting period of the Senate will be increased by an additional week into the first week in December. So we are anticipating, although we can't guarantee, that this bill will come into effect before Christmas. So some of the main aspects within this current bill, which we'll go through in a bit of detail, includes the prohibition upon pay secrecy, limiting the use of fixed or maximum term contracts, expanding to a certain extent the current and existing flexible working provisions which exist within the Fair Work Act, amendments to enterprise bargaining, which seems to be getting a lot of press and media attention, expanding the small claims process, and of course, addressing sexual harassment within the workplace. Now, if that wasn't enough of a Christmas present for businesses, the government has indicated that there will be a further tranche of legislation which is likely to be introduced next year. Now, some of the main drivers or policy agenda items which we anticipated would be introduced in this particular bill has been omitted. So whilst we don't know the content of the next bill which will be introduced next year, we can assume that some of the factors or matters which will be included include the increased focus upon insecure work, that is casualisation, the use of on-hire labour and other factors. On-hire wage parity, meaning that effectively the use of on-hire labour it cannot be at a level below direct employees. Increased compliance, prosecution and penalties, particularly in relation to serious and systemic underpayment of wages. Potential introduction of criminalisation of serious underpayments of wages, and further protection around vulnerable workers. So these are the main things which we have noted are omitted from the current bill and what we anticipate, therefore, to be included within the next tranche in February. But as you can see, we already know that the legislative agenda of the government is quite full. We anticipate that there will be further significant amendments into 2023, and we'll provide you with as much information upon those changes and the practical effect as best we can. So turning to the current bill, the Secure Jobs and Better Pay legislation. Now, of course, in this session, we can't discuss every aspect which is contained in the bill. Obviously, time wouldn't permit. But there are a lot of details that I would probably suggest that are getting media attention that probably wouldn't really be relevant to a large number of those of you on today's session. Yeah. So whilst we could talk about in detail the enterprise bargaining amendments and some of the more topical areas such as industry-based bargaining, it's probably going to have very limited practical use to many of you. So what we're wanting to do is go through some of the more practical elements of the bill to discuss and explain the matters which we think need to be addressed by all businesses. And of course, there'll be Bianca and myself and other members of the team which are happy to support you in any of the other aspects which might apply to a limited number of people in today's session. So probably the first thing that we wanted to discuss is a provision which is included within the bill, which prohibits the ongoing pay secrecy arrangements which exist within many employment structures. The government has noted that the maintenance of pay secrecy requirements is artificially reinforcing pay inequality amongst the workforce, in particular, generating and contributing to pay inequity. Now, with the gender pay gap currently at 14.1%, this is something that the government is very keen to address. And there are a number of things which Bianca will raise, which the government is doing in that positive space. But under the current provisions proposed within the bill, employees will have a positive right to disclose the terms and conditions of their employment, including their salary or other forms of remuneration, without any fear of victimisation or reprisal from their employer. It's interesting to note that that right extends both in terms of a person's current employment, but also after their employment ceases, meaning that they are free to disclose the terms and conditions which they enjoyed with their former employer after they left. There's also a positive right upon an individual to inquire, meaning that there is nothing wrong with any individual asking other persons or colleagues within an organisation to disclose their terms and conditions, meaning that the fact that they are requesting the disclosure of itself is not anything problematic. Recognising that many contracts of employment and other industrial instruments contain provisions which currently prevent these type of inquiries or disclosures, the bill goes a step further to say that any term or condition of a contract or industrial instrument which maintains or requires pay secrecy is effectively void and unenforceable. Now, what's interesting in this, in my view, is the government has introduced these particular provisions as what we call a civil remedy provision, which means that contravening these particular provisions is considered to be a civil remedy breach, which may result in significant penalties. For serious contraventions, that may result in up to $666,000 as a penalty applied against the company, and $133,200 as a maximum penalty against any individual who is knowingly involved in that contravention. So significant penalties which may flow. Now, in my view, this has the potential to create some significant engagement issues within an organisation. It also has the potential to create dispute. So I would be certainly suggesting that organisations should be looking at both of their existing contracts of employment, but ways in which they can start to consider and collate information, objective information, concerning a person's contribution and the basis upon which they're currently remunerated. Another significant change is the limitation on the use of fixed and maximum term contracts. Now, as outlined in that initial slide around the agenda and objectives in Tranche 1 and Tranche 2, the Labor government is keenly focused upon insecure work, or what they perceive to be insecure work models. And that isn't just limited to the use of on-hire labour, but is extending into the use of fixed term and maximum term arrangements. The government recognises, as it's explained within the explanatory memorandum which sits alongside the bill, that fixed and maximum term contracts certainly have as its place within modern employment structures. However, it does note that the ongoing use of those models or engagement models tends to promote job insecurity. So what it has proposed is to create limitations upon the use of these fixed or maximum term contracts. Initially, there's an indication which says that no fixed or maximum term contract can be for a period of time greater than 2 years, excluding any extensions which may have occurred in that period, nor can a fixed or maximum term contract be renewed or extended more than once. Now, there are, in fact, very significant anti-avoidance provisions which have been included in the first redraft of the bill, which indicates that significant penalties may apply to an organisation which terminates the employment of an individual on a fixed or maximum term contract and then re-employs or employs another on similar or like terms, simply to avoid this type of arrangement. The legislation also introduces a dispute process before the Fair Work Commission, where an individual can raise the nature of their engagement with the Fair Work Commission, which has the power to mediate, conciliate, or arbitrate upon a consent basis. Now, in the recent changes which has been made to the bill, this particular provision has been deferred for an initial 12-month transitional period, meaning that this strict prohibition actually is deferred, or the commencement of it is deferred for a reasonable period of time. However, we do need to start considering that engagement structure and whether there are other alternative options available to you. What the bill does say is that in the event that an individual arrangement contravenes this section, that is for a greater period of 2 years or extended more than once, it doesn't automatically terminate the employment, but rather the employment will be ongoing, although deemed permanent and on an ongoing basis. So something important to consider. There are limited exceptions and exclusions which apply, and the burden is upon the employer to establish that one of those limited exclusions apply in those particular circumstances. Another reasonable change which has been included is an amendment to the current flexible working arrangements contained within the Act. I assume many of you on today's call will be very familiar with the changes to the flexible working arrangements, which was introduced and inserted within the modern award structure. So you'll be familiar with those, but there was a slight difference between the arrangements in the Act versus the award. And what these changes, quite sensibly in my view, do is to create a level of symmetry between the two. And now what will happen is the Fair Work Act will effectively replicate and mirror the modern award requirements, meaning that the circumstances where an individual can request flexible working arrangements is extended slightly to include circumstances where an individual is experiencing family or domestic violence. And it also places a direct obligation upon the employer to have a conversation with the employee concerning the request, to provide written reasons in relation to any refusal, and as well as a positive obligation to identify and notify the employee of any alternative role which the company could accommodate the request. Together with what I mentioned previously around the fixed term arrangements, there is also an expansion of the Fair Work Commission's powers to hear disputes in this particular area. And again, contravening this particular provision is viewed as a civil remedy provision, meaning that significant penalties may apply both to the organisation and any individual which is knowingly involved in that contravention. Now, in the interest of time, we don't have the luxury of going through all of the amendments currently proposed with regards to enterprise bargaining or agreements. They are quite comprehensive and quite detailed. There are in certain areas quite significant changes in relation to industry-wide bargaining as an example. Not only do I have the time, but I do anticipate that there will be some level of change arising from the scrutiny applied by the Senate. So what I wanted to do is just go through a very few small areas in terms of enterprise bargaining and agreements. The first is in relation to zombie agreements in inverted commas, being agreements which are effectively created or approved under an industrial framework prior to the Fair Work Act system in 2010. Now, as we know, these zombie agreements often contain terms and conditions which are less favourable than the current modern award structure. We also know that those zombie agreements were approved in a significantly different legislative framework, which don't apply the current boot test or other assessment. And we also know that businesses which are able to operate under those agreements often have, as the government has worded, an unfair trading advantage by having the benefit of the lower terms and conditions that that document creates as compared to other businesses required to operate under the pay and entitlement structure of the Act or the modern award system. So the current bill proposes that those zombie agreements will be effectively sunset or terminated after an initial grace period of 12 months. It's important to note that a business can make an application to the Fair Work Commission to extend that grace period for a further period of time up to 4 years, but certain criteria must be met in order for the Fair Work Commission to authorise or approve that. Broadly speaking, I think that any business operating under an enterprise agreement which predates 2010 should be approaching this on the assumption that that zombie agreement will come to an end within a limited period of time, and certain preparation for that process should be taking place now. There's also some introduction of rules and conditions around circumstances when an employer can unilaterally seek the termination of an enterprise agreement after its nominal expiry date. Simply, the bill proposes that an employer can no longer unilaterally seek to terminate an agreement where doing so will result in the reduction of an individual's terms and conditions of employment. And there is also some sensible alterations to the current controversial boot test application, meaning that the government is seeking to revert that test back to more of a overarching global assessment as opposed to the current line-by-line comparison, which is currently undertaken by the Fair Work Commission. Now, that of itself is currently viewed by many businesses as a block or barrier to undertaking a bargaining process, meaning that the benefits of undertaking a bargaining process is somewhat limited. And these alterations to the boot test and bargaining arrangements may alter that perception moving forward. So it may be that businesses need to reassess whether an enterprise bargaining process is fit for them and whether there's potential benefits to be achieved. So having said that, I know that we've got a lot to discuss today, and I'm sorry that we can't get through every aspect of that particular bill. We also appreciate that for some of the larger businesses on today's session, you might have more structured or complex advisory needs. So we are more than happy to support you in that area. We're more than happy to have a discussion with you around your particular business and how we can support or what your requirements are. On screen, there's currently a QR code. If you would like to scan that and enter your details, that will take you through to our advisory function. And one of my team would be more than happy to give you a call back and to support you with any of these proposed legislative amendments and the impact upon your business. So having said that, I'll now hand over to my colleague Bianca, who will talk you through the proposed changes to the sex discrimination legislation. Thanks, Bianca.
Thanks so much, Wes. So some of the changes that we're going to be talking about today came about as a result of the Respect at Work report handed down by the Sex Discrimination Commissioner, Kate Jenkins. So way back when, June 2018, I guess against the backdrop of the momentum of the Me Too movement and recognition of the prevalence of, and let's face it, immense harm caused by sexual harassment in Australian workplaces, the Sex Discrimination Commissioner, Kate Jenkins, and the then Minister for Women, the Honourable Kelly O'Dwyer, announced the National Inquiry into Sexual Harassment in Australian Workplaces. And it was actually the Australian Human Rights Commission that was tasked with undertaking this inquiry. And as part of the inquiry, the Commission was tasked to review and report on a number of workplace harassment initiatives and make recommendations in relation to a number of areas. And probably most relevant for today's session is, part of that review was looking at the current legal framework. And so as a result, we have before us the Anti-Discrimination and Human Rights Legislation Amendment Respect at Work Bill 2022. And this was introduced on the 27th of September 2022 and seeks to make amendments to two key pieces of legislation. So the Sex Discrimination Act and also the Australian Human Rights Commission Act. And obviously, as Wes has been going over the Fair Work Legislation Amendment, Secure Jobs, Better Pay Bill 2022, I'll be focusing on some of the changes when it comes to the sexual harassment space as well. All right. So I think it's safe to say probably the most talked about change for this bill has been the inclusion of a positive duty to eliminate sex discrimination. So what does that look like? So section 47 capital C of the bill sets out the positive duty on employers and PCBUs to take reasonable and proportionate measures to eliminate, as far as possible, unlawful sex discrimination, sexual harassment, including harassment on the ground of sex, hostile working environments, which I'll explain what that means a little bit later, and acts of victimisation as well. So the matters that will be taken into account in determining whether a duty holder complies with this positive duty or not will include things like the size of your business, nature and circumstances relating to your business, your resources, whether they be financial or otherwise, and also the practical nature and the costs of steps to eliminate conduct covered by the duty as well. And of course, any other relevant matters. It's important to note that the duty will extend to conduct by third parties, such as customers or clients as well. Very helpfully, the positive duty is not defined under the bill, but what is a reasonable proportionate measure will depend on those factors that I just outlined. Look, the explanatory memorandum does provide some examples, and I thought it might be helpful to go through that example of what it could look like for the positive duty under section 47C to actually be met. So one of the examples involves the owner of a large hotel in a ski resort with 60 employees who were largely part-time or casual. So we're going to talk about Ada and Daniel. So Ada and Daniel recognise the risks associated with having short-term workers, and they develop an action plan for complying with the positive duty. As part of this plan, Ada and Daniel tasked their human resources officer with developing a policy on harassment and discrimination, and really ensuring that this is part of their onboarding process for new staff. Ada and Daniel also require managers to complete externally provided training on harassment and discrimination and on an annual basis. And the managers are then responsible for ensuring their staff are aware of the policy and reiterating behavioural standards. So that's an example of measures for that size of business. In that case, Ada and Daniel are actually likely to be compliant with the positive duty under section 47C. So if we go to the next slide, one thing to be aware of is that section 106 of the Sex Discrimination Act actually provides that if an employee or an agent of a person in connection with employment of the employee, or if they're an agent in connection with the duties of the agent, engages in conduct that is unlawful under the Act, then the Act applies to that person as if they had done that act. So in effect, you can be held vicariously liable for the actions of your employees or of your principal, your agents. So there is an exception that applies, and that is if it is established that the person took all reasonable steps to prevent the employees or agents from doing the acts complained of. Very helpfully, the explanatory memorandum does talk about that this positive duty is intended to align with section 106 of the Sex Discrimination Act. So in effect, if you've met your positive duty, then you won't be vicariously liable for the actions of your employees or agents. So in effect, you can essentially kill two birds with one stone. All the steps you take to meet your positive duty obligations will in turn assist you in defending any claims where one of your employees or workers goes off the rails. So I think that's really important to note. So I did mention that earlier that I would talk about this concept of hostile workplaces. So the bill also includes this proposed amendment to insert a prohibition on conduct that subjects another person to a workplace environment that is hostile on the grounds of sex. So the Respect at Work report found that sexual harassment may occur where a workplace environment is sexually charged or hostile, even if the specific conduct is not directed at a particular person. So what are we talking about here? So, you know, it was noted that things such as conduct such as displaying obscene or pornographic materials, if there was general sexual banter or innuendo and offensive jokes, that these sorts of things can result in people of one sex feeling unwelcome or excluded by the general environment. And it's the very existence of these environments that can actually increase the risk of people experiencing other forms of unlawful discrimination, such as sexual harassment. So if the bill is enacted, then it will prohibit subjecting a person to a hostile workplace environment on the grounds of sex. So again, it's conduct that's not directed at a particular person. Instead, it's the general environment, and it's not directed at anyone in particular. There is a reasonable person test. So subjecting a person to a hostile workplace environment includes a requirement that a reasonable person would have either anticipated the possibility of the conduct being offensive, intimidating, or humiliating to someone by reason of their sex or characteristics that generally appertain or imputed to persons of that sex. So whether the conduct is considered unlawful, there'll be a number of factors that will be taken into consideration. So first one being the seriousness of the conduct, whether the conduct was continuous or repetitive, and the role or influence or authority of the person engaging in the conduct as well will be relevant. And of course, that catch-all, any other relevant circumstance. Another important change is the role of the Australian Human Rights Commission will change as well if the bill comes into effect. And so the Australian Human Rights Commission will have new powers to monitor and assess compliance with the positive duty to eliminate unlawful sex discrimination. So again, the Respect at Work report recommended that, look, if you're going to implement positive duty, then this has to be accompanied by an appropriate enforcement mechanism to help ensure it is effective and employers are engaged with their legal obligations. And it was also thought that an appropriate enforcement mechanism would also ease the burden on individuals by enabling actually the Commission to initiate action to address unlawful discrimination, rather than leaving that solely to individuals making complaints. So the powers are pretty wide-reaching. They're able to conduct inquiries, they can issue compliance notices, and can apply to the federal courts for orders to direct compliance with these compliance notices, and also require employers to enter into enforceable undertakings. So look, there will be mechanisms where employers and PCBUs will be entitled to procedural fairness. They'll be able to seek internal reconsideration of these compliance notices through the Australian Human Rights Commission, or they'd be able to apply to the federal court for a review of a compliance notice as well. The other key thing is that the Human Rights Commission will have powers to conduct inquiries into systemic unlawful discrimination or suspected systemic unlawful discrimination. So what is meant by that is unlawful discrimination that affects a class or a group of persons and is continuous, repetitive, forms some sort of pattern. And, as a result of that sort of systemic or suspected systemic conduct, the Commission can actually commence an inquiry either after receiving a complaint or on its own accord. So we are going to have a little bit of leeway in relation to get ready and prepare, because, for some of us, we're going to have to look at our current processes and procedures to ensure that we are compliant. So the Human Rights Commission's new powers will only commence 12 months after the changes commence. So to give everyone a little bit of time to understand their obligations under the positive duty and implement those changes if necessary. So what are some practical steps? Where do you start? I think the first thing to do is undertake a risk assessment in respect of your, respect of risk in relation to sexual misconduct, sex discrimination in the workplace, and think of it as, what would you do if you're conducting a work health and safety assessment, and sort of apply the same lens, if you like, to this. The things you could look at is, look at the demographics of your team, how you engage the team, working patterns, conditions of work. You know, there's some things like remote work and things like that, or you know, overnight stays which could pose some problems in this space. You know, whether there's any power or gender imbalances in the team. Are there some risks that are unique to your business or your industry? If you do conduct culture engagement surveys, take a look at those results and see if there's any sort of problems that you can identify. And then if you have a grievance procedure, look at the nature and frequency of complaints that are raised, again, through those channels. You know, once you've done that assessment, you then look at, okay, we've identified the risks. And so what are the reasonable and proportionate steps that can be taken within the context of your business and organisation, you know, as soon as possible to reduce those risks? And I think some of the key call-outs, you know, bare minimum, you'll need to implement policies and procedures which clearly prohibit discrimination and harassment in the workplace. And if you already have a policy, review it to ensure that it deals with your positive obligation under the Sex Discrimination Act, as we've just been through. Then develop effective discrimination and harassment training, and that needs to be rolled out periodically to staff. You know, it's not a once-off set and forget. You do have to make sure that people are always aware of their obligations and your expectations. You know, you may want to keep, and I think you recommend that you would keep a record of people's attendance at these training sessions, and get them to sign off on the policies and procedures, you know, to say that they have obviously read and understood their obligations under that. Make sure that you have an effective and timely grievance procedure to respond to complaints. And again, ensure, and this would be through your policies and procedures, that everybody understands that if they do engage in conduct like this and it's substantiated, that, you know, disciplinary action will follow. The other thing I think is a bit of a culture piece, one last thing, sorry, and that's encouraging or requiring employees to make reports. You know, encourage a reporting culture if they experience, witness, or they hear about any sex discrimination, sexual harassment in the workplace. And clearly explain how employees can make reports and confirm that they are protected from victimisation if they do in fact speak up and report this sort of conduct. All right, let's get on to we'll go to the next slide. So this is again, there's a new prohibition on sexual harassment in connection with work, which will feature again if the bill comes into effect under the Fair Work Act. So this is the insertion of prohibitions on sexual harassment, and this was in line with a recommendation again coming out of the Respect at Work report. So it's basically a new dispute resolution framework, which is somewhat in line with our existing general protections regime, if some of you are familiar with that. So, you know, if you are familiar with that, you'd understand that disputes are first dealt with by conciliation and mediation, but they can progress to arbitration under the by consent before the Fair Work Commission, or if there's no consent, can be escalated to the federal court, federal circuit court, or federal court. The definition of sexual harassment comes from the Sex Discrimination Act. So just a refresher. So a person sexually harasses another person if the person makes an unwelcome sexual advance or an unwelcome request for sexual favours to that person who's harassed, or engages in other unwelcome conduct of a sexual nature in relation to the person harassed. There is a reasonable test component there. So, you know, it has to be in circumstances in which a reasonable person, having regard to all the circumstances, would have anticipated the possibility that the person harassed would be offended, humiliated, or intimidated. What it's not is conduct that is consensual. It has to be conduct of a sexual nature. And as I said, there's that reasonable person test as well. All right. So what's going to happen under this new regime? So upon application, the Fair Work Commission can make a stop the sexual harassment order or otherwise deal with a dispute. So unlike the Fair Work Act's current dispute jurisdiction to issue stop sexual harassment orders, it does appear that the applicant need not be a current employee, and the applicant may have up to 2 years to make a dispute application after the alleged contravention, which, you know, is quite a lengthy period of time. In relation to a stop sexual harassment order, the Fair Work Commission must be satisfied that the aggrieved person has been sexually harassed and that there is a risk that the aggrieved person will continue to be sexually harassed in contravention of the prohibition. Now, the powers in relation to this are pretty broad. The Fair Work Commission can make any order it considers appropriate, other than an order for the payment of some sort of monetary compensation. So if an application does not include an application for the Fair Work Commission to make a stop sexual harassment order, the Fair Work Commission may exercise its dispute resolution functions, which is there's new requirements under the bill and also some of the established provisions under the Fair Work Act. What is apparent is that, you know, very similar to the current general protections regime, any dispute conference must be conducted in private. If a dispute remains unresolved and the Fair Work Commission is satisfied that all reasonable attempts to resolve the dispute will be unsuccessful, then the Fair Work Commission will issue a certificate to that effect and advise the parties if it considers that, you know, that any further court application or arbitration would have no reasonable prospects of success. Once that certificate is issued, then the dispute may be determined, again, as I mentioned, by the Fair Work Commission, arbitrating the matter by consent or by a sexual harassment court application. So through arbitration, the Fair Work Commission could make a range of orders, including an order for the payment of compensation to an aggrieved person, an order for the payment of lost remuneration, and an order requiring a person to perform any reasonable act to address loss or damage suffered by an aggrieved person. And a contravention of an arbitration order is a civil remedy provision, as Wes was talking about earlier in the presentation. All right, well, I think you've heard enough from me this afternoon, so I might actually hand over to Annette now to see whether you have any questions or anything like that.
Fab. Thank you so much, Bianca and Wes. Wonderful presentation, and I'm sure everybody has taken on board what you've had to say and start preparing for these workplace changes. Before we do go into questions, though, I did want to cover off this slide here. It's an offer just for the participants today, an opportunity to book a free HR health check, which is valued at $750. Safe to say that conducting regular checks on your business's workplace practices is one of the best ways to avoid a compliance issue. And think wage theft and general protections claims. And unfortunately, these matters can be costly and can negatively impact on your business's reputation. So when was the last time you did a compliance audit on your business? If compliance has been on your mind, don't put it off any longer. You can claim your 30-minute HR health check valued at $750. All you need to do is book using the QR code on the screen. And there are limited places, so we're only giving away 20 health checks today. So if you do want to take us up on this offer, I suggest that you jump onto it now and complete the form. I'll give you just a couple of seconds just to do that, so that you know, you can complete the form. So just jump on to the QR code there. We're also going to put in the URL code in the chat there, so you can head to that if you are on mobile. Okay. We might move on to the questions now. Okay. There are quite a few here. We've got a lot of questions, as I expected. We'll get through as many of these as we can, but I am conscious of time. So if we can't answer your question today, we'd like to offer you to try our advice service for free, where you can speak to a workplace relations expert about your concerns. And we'll be in touch with you after the webinar with details on how you can arrange this. So just look out for an email from Wes. Okay, let's jump into the questions. I'm going to give the first question to you, Bianca. What are the practical changes which I need to implement?
Where do I start? I think there's a lot, and I think probably a starting point would be to probably look at your employment contracts. I mean, I think that's a quick win. You know, as Wes mentioned, a lot of standard employment contracts will have those pay secrecy clauses. So I think that's, you know, that's something I would look at straight away to look at amending. Policies and procedures. Obviously now with the positive duty to eliminate sex discrimination, you know, is it something that you want to include in your contracts? Are your current policies up to scratch? Do you have a comprehensive grievance procedure and things like that? And you may also want to look at your flexible work practices, again, policies and procedures, and see what you're doing in that space. So, you know, don't want to overwhelm people, but I think there's a lot that you could be looking at to be prepared.
Thanks, Bianca. Hopefully that's answered your question. If you do need more information, again, please get in touch with us and we'll put you through to a workplace expert. Wes, this one's for you. When is the legislation likely to come into effect, and is there likely to be any significant changes, which means we should defer action until the law is in place?
Yeah, really good question. When the legislation or the bill was introduced, many people were anticipating that it was unlikely to be finalised until the February sitting of Parliament. We now anticipate that it's going to be introduced prior to Christmas. As I mentioned before, it's proposed that the Senate will sit for an extra week, the first week in December, to enable consideration of the bill and a vote. So it's unlikely that any of the significant changes to the legislation which we've discussed today will be changed in the Senate, and there's broad consensus and approval for that. Discussions that I'm having with my clients and those within HR Assured is that we should be anticipating that the legislation will be introduced prior to Christmas. So I certainly don't think that there is any benefit in deferring or waiting any longer to see what those changes are. As Bianca mentioned, there's a lot of practical steps that should be considered and implemented. So I think the sooner you can start that journey of discovery, both in terms of what the practical elements of the bills are and how it impacts on your business, and start to plan for it, the better. So, you know, plan for this side of Christmas, plan for immediate action. And then there is going to be, as I said, an anticipated tranche 2 introduced some stage in the first quarter of next year. So I also think you should be planning that there is going to be some further significant announcements that we will share with people moving into next year as well.
Great, Wes. That doesn't really leave a lot of time, I guess. Christmas is only...
Merry Christmas. Lots of interesting things to read over your Christmas break.
Wonderful. Right. Poolside reading.
Absolutely.
Okay, we do have lots of questions. I know we're running out of time, so I'll just throw a couple more over.
Sure.
I am not a large business with an HR department. In meeting the positive duty requirements under the Sex Discrimination Act, am I expected to do the same things as a large business? Great question, Bianca. Can you answer that one?
Absolutely. And yeah, it is a great question. Obviously, the example I discussed, I use sort of a mid-sized business, but the good news is that the measures you need to take are going to vary depending on your business. And the obligation will vary depending on the size and nature of your business and your resources, whether they be financial or otherwise. Maybe it might be helpful. There is an example under the explanatory memorandum where they use an example of a business that has 8 employees and what what would that look like for that business to meet its positive duty obligations? So they talked about, the basics I think every business needs to have. So, implementing a policy and procedure, making sure you give everyone a copy of that, discuss the policy, let them know how they can make a complaint. And then discuss the policy regularly, whether, it be informally, formally, in your catch-ups and things like that. So there is this greater awareness. And so that is an example that's in the explanatory memorandum for a smaller business. But, as I said, I think all businesses are going to be expected to have that bare minimum of comprehensive policies and procedures, and making sure that your employees are aware of the obligations in those policies and procedures. It's not something that's sitting on the shelf collecting dust. It needs to be part of your day-to-day.
Fab. Thanks, Bianca. I think we'll have time for one more question. Wes, this one's for you. We use maximum term agreements with our workforce, and we are dependent on government funding. We also can't use government funding to pay redundancy costs. How can we approach this?
Yeah, actually, it's a really good question. I think we need to emphasise that the government has said quite rightly that there is a place for fixed and maximum term contracts within modern engagement structures. I think what they're trying to address, though, is the inappropriate use of those structures on an ongoing basis, which does in fact lead to job insecurity, which is a big focus of the government in terms of that insecure work campaign. There are a number of exceptions, which I alluded to in the presentation. There are quite a few of them, so I didn't see that we had time to go through it. But one of the exceptions is where an organisation is dependent upon government funding, which is limited in its duration. So in that sense, there may be a valid reason for you to continue in that engagement model. Having said that, the onus is upon the employer to establish that there is a legitimate reason to continue offering fixed or maximum term contracts beyond that structure of 2 years or more than once. So there are a number of other reasons, which I won't go through today, but it does seem from the information that you've given that you might fall within one of those exempt categories. And perhaps there's a need to provide or obtain rather specific advice just to double check that, and also how you can communicate that into your workforce. One other thing that I should say that I omitted from discussing in the presentation is that there is also a new requirement with fixed and maximum term contracts to give a fixed term employment status certificate to individuals as well. So there's another requirement, much like the casual information statement and Fair Work information statement. So there's going to be another information statement which the Fair Work Ombudsman will produce. And if you are engaging people on a fixed or maximum term basis, you have to provide that to them as well.
Sounds really complicated, Wes.
Well,
We're going to end up with a small book.
It is. It keeps us in work. That's all I can say.
Yeah. Oh, look, thank you very much, Wes and Bianca, for your valuable content today. And I'm sure everybody here has walked away with some really useful information that is going to help them. For everyone online, thank you very much for spending your time with us watching this webinar. We do hope to you took advantage of the initiatives that we've offered today, and that you've walked away with the information you need. Again, remember, if you do need help, you can reach out to us. We are going to send out an email after this webinar with all the information on how you can get in touch with us, and you can also watch the recording from that email. And we do webinars on a regular basis. So this is our last one for the year. We will be back in 2023. So please look out for those emails promoting our webinars, and follow us on social. Thanks again, guys, and enjoy your day.
Thanks, everyone. Have a great day.
Thanks,
and Merry
Annette.
Christmas.
Thanks, everyone.
Thanks.